At what point does political speech become criminal? To find out, you have to read Schenck versus United States. But it's 10 pages. Don't have time for that? I've got you covered. This is too long, didn't read, where I normally cover New York Court of Appeals cases, but this is part of a special series I'm doing on landmark cases from the United States Supreme Court. This is the episode on the case of Schenck versus United States, published on March 3rd, 1919. The citation for this case is 249 U.S. 47, 1919. The issue in this case is whether otherwise protected political speech can become criminal. To understand and appreciate this case, you have to know a little bit of background. The first concept you have to understand is the First Amendment to the Constitution, which guarantees freedom of speech. It specifically states that it prohibits Congress from abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. What this generally means is that speech cannot be curtailed by the government, and the most protected kind of speech is political speech. Next, you have to understand the Espionage Act of 1917. In 1917, the United States had just entered World War I after years of watching Europe and Asia descend into violent war. Patriotism was very high, but so was fear and suspicion. There was concern that America's enemies had spies and traitors within the country. Congress, eager to calm down dissent to the war and ensure national unity, passed the Espionage Act of 1917. That law made it illegal to interfere with military operations, including recruitment. It criminalized acts that were deemed disloyal or could incite insubordination within the armed forces. In passing the law, the government argued that during times of war, the nation's security interests outweighed certain individual liberties, including aspects of free speech. The act essentially criminalized any speech or action that could hinder the war effort or incite disloyalty within the military. This included speaking out against the draft, criticizing the war, or distributing materials deemed obstructive to recruitment. While the government argued for the necessity of such measures, the stage was set for a clash between national security and the cherished right to freedom of speech. Charles Schenck was a member and the general secretary in a leadership position of the Socialist Party of Philadelphia during World War I. Schenck and the executive committee of the Socialist Party of Philadelphia authorized the creation, printing, and mailing of more than 15,000 flyers to be sent to men who were going to be conscripted into the military draft. The flyers urged the reader not to submit to the draft, saying that military conscription was a violation of the 13th Amendment prohibition against slavery. The flyer called forced conscription into the military involuntary servitude. The flyer urged pacifism and said it was patriotic to resist the draft. These actions, though driven by deeply held beliefs, brought Schenck into direct conflict with the Espionage Act. Schenck was arrested for violating the Espionage Act of 1917. Schenck appealed his conviction, claiming that the law violated the First Amendment and deprived him of free speech. Schenck argued that his actions were protected under the First Amendment's guarantee of free speech. The trial court, however, disagreed, finding Schenck guilty. His conviction was upheld by the Court of Appeals. Undeterred, Schenck appealed his case to the highest court in the land, setting the stage for a landmark decision that would shape the future of free speech in America. The Supreme Court addressed the issue head-on. Justice Holmes, writing for the unanimous court, conceded that in normal times the content of the flyer would not be so bad. Justice Holmes wrote that it would normally be protected speech, but there are limits, constitutional rights. The important quote here is this: "The character of every act depends upon the circumstances in which it is done." Justice Holmes makes this famous analogy: free speech does not protect a man from falsely shouting fire in a theater and causing a panic. If the speech creates a clear and present danger that it will create a situation Congress has the right to prevent, then it can be criminalized. And that's what we have here. Congress has a right to prepare the country for war, including recruitment of young men into the military. Schenck's pamphlet created a clear and present danger that Congress's powers would be affected. That allows this kind of speech to be criminalized. The Supreme Court therefore upheld Schenck's conviction. The Schenck case, though decided over a century ago, continues to resonate in legal and societal debates about the limits of free speech. The court acknowledged the importance of free speech, but argued that it was not absolute, especially during times of war. But beyond that, it established that the government can, under certain circumstances, restrict speech that poses a direct threat to national security. On the other hand, it sparked a century-long conversation about the balance between protecting individual liberties and maintaining order during times of crisis. The case serves as a stark reminder that the freedoms we cherish are not absolute, and that their boundaries are constantly being tested and redefined. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.